juvenile and family court judges, and I work almost exclusively within our Resource Center on Domestic Violence, Child Protection, and Custody, where I provide trainings like today's trainings on the intersection of domestic violence and child welfare. Before coming to the Council, I was a legal services provider for many, many years. I started out working with migrant farm workers in Colorado. I then moved to Northern Nevada, where I worked as a child advocate attorney for children involved with the child welfare system for about 7 years. And then I worked at Nevada Legal Services as a staff attorney, senior attorney, and eventually directing attorney. And in that role, I worked with immigrant victims of domestic violence, providing immigration relief through VAWA, U visas, and battered spouse waivers, which we will talk about later in today's webinar. I'm really happy to be able to provide this webinar today and talk about the unique challenges that face immigrant victims of domestic violence that become involved with the child welfare system and how we can seek to improve practice and the experience for those families. I'm also thrilled to be here today with Emily Butera, who is a Senior Policy Advisor for the Migrant Rights and Justice at the Women's Refugee Commission. Emily is an expert on the protection of families dually affected by U.S. immigration and child welfare systems. Her work focuses on mitigating the effects of immigration enforcement, detention, and removal on family unity, parental rights, and child well-being. She has extensive experience advocating before Congress and executive agencies on a wide range of issues, including detention reform, the protection of unaccompanied children, and gender inclusivity in immigration law and policy. Emily also conducts field-based research on detention and asylum policy and has authored numerous reports on these subjects, including Locking Up Family Values, the Women's Refugee Commission's groundbreaking report on family detention, and Torn Apart by Immigration Enforcement, which is the first ever national report on parental rights in immigration detention. In addition to her work with the Women's Refugee Commission, Emily has worked as an advocate, writer, policy strategist, and program manager for local and national immigrant and refugee rights organizations, including the Lutheran Immigration and Refugee Service, Catholic Legal Immigration Network and Asian Human Services, as well as for the UN Refugee Agency. As you can tell, we're really, really pleased that Emily was here to join us today. She has a ton of experience, and without further ado, I'm going to go ahead and pass this over to her.
Thanks very much, Melissa, and thank you to NCJ for the invitation to be with you. Thanks as well to all of you who are taking some time out of your day to have this important conversation with us. Just as a bit of framing, I know that family separations at the border are in the national spotlight right now and are probably in the forefront of many of your minds. It's an issue that both of our organizations are very concerned about. We're doing quite a bit of work on that front at the Women's Refugee Commission. But for today's conversation, we're going to try to focus on the topic of immigrant victims of domestic violence and what happens when they also become involved with the child welfare system. In the second half of the presentation, we'll talk through ways that child welfare and other professionals can help when cases involve detention and deportation, some of which may be the result of family separations at the border. So just wanted to give that disclaimer and a bit of framing for the conversation. And without further ado, I think we'll jump in. Melissa, did you want to quickly go through the learning objectives before we start to get into more of the substance?
Sure. So as you can see here in the slide, we have 3 main learning objectives for today. The first is to give you sort of a 1,000-foot overview of how immigration status and immigration proceedings impact families, and Emily's going to go ahead and give us that information. We also want to talk about how domestic violence poses unique challenges for immigrant families, and I'll go ahead and talk about that. And then in the latter part of the webinar, we're going to take these 2 topics and bring them together and talk about innovative ways that we can, as professionals working with the child welfare system, better serve immigrant families experiencing domestic violence that are also involved with child welfare. And you all took a poll when you joined us, and it looked like we have some legal services providers, a good number of domestic violence advocates, some social workers, and some CASAs, it looked like at least one better intervention provider. So we have a great range of folks with us today, and we're really excited about that. So we'll try to make sure that we present this in a way that's meaningful for all of you from your different perspectives, because really, as you know, if you're working in this field, in order to better serve families, we need to all work collaboratively and together. So hopefully this will all, you'll find all of this helpful regardless of where you're coming from.
Great. Thank you. So we're going to start, as Melissa said, at the 30,000 foot level. This may be new information for some of you and old hat for others, but we felt that it was important to give everyone a common foundation for the discussion, and we'll become increasingly more granular, both as we talk about what happens to individuals in the immigration system, then as we talk about what happens specifically to domestic violence survivors in the immigration system, and finally, what are the strategies that you can employ when you are serving a child, a family, a victim who is crossing these multiple systems and who is trying to achieve the best possible outcome for themselves and their families. First and foremost, what does immigrant mean? How do we define it? There's a lot of terms that are up on the screen, and I'm not going to walk through each of them in extreme detail, but I do want to point out that it's never clear who comes before you when somebody comes onto your caseload. And obviously, as you know, you can't ask a question about an immigration status. The judge can't ask a question about immigration status. But when you build a rapport and trust with the individuals that you're serving, we often find that information begins to come out. And many families, as you probably know, are mixed immigration status, where some members are citizens, some are non-citizens. They can be lawful permanent residents, i.e. green card holders. They can be people here on employment visas or student visas. They might be an asylee or a refugee, somebody who's received protection due to being a victim of trafficking or domestic violence. They may have DACA. They may be trying to figure out what happens when their TPS status is revoked. And they may be undocumented. Any individual, and we'll talk a little bit more about this as we go through the slides here, who is not a U.S. citizen is vulnerable to apprehension, detention, and deportation by ICE. So just keep that in mind, whether an individual is acutely at risk under some of the policy changes that we've seen, or whether an individual's risk may be low but still there. That fear of possible instability in their situation, I think, is always a factor that we need to be mindful of in thinking through a service plan and how to deliver the best services possible. So stepping forward into looking at the different agencies and personnel that you may come into contact with if you interface with the immigration system. Obviously, the Department of Homeland Security is the umbrella organization charged with enforcing U.S. immigration law. Within that, there are a number of different components. Customs and Border Protection, obviously responsible for border enforcement, as well as Immigration and Customs Enforcement, who is responsible for interior enforcement, as well as for immigration detention facilities. If you're working with somebody who's apprehended by immigration authorities and taken into custody, it's most likely that they are in ICE custody. And so there are different individuals in the ICE system who could be your first point of contact if you need to talk to that individual or need to make arrangements for that person to have access to a child welfare case plan, what have you. Deportation officers are often the first point of contact for individuals like yourselves. That's the person who's in charge of the day-to-day immigration case. But there are also ICE field office directors in the ICE regions across the country. And towards the end, we'll provide information on how you go about finding the different ICE offices and the points of contact there. Obviously, you've also been hearing a lot about the Department of Health and Human Services as well as the Department of Justice in the news in recent weeks with the separations at the border. Department of Health and Human Services is responsible for the care and custody of an unaccompanied child, essentially an undocumented child under the age of 18 who's outside of the care of their parents. If you have a family unit that's picked up in the interior of the U.S., they could be separated with the parent going to ICE and the child going to HHS. And in some instances, when an individual is actually being prosecuted for a crime, whether that's the crime of unlawful entry or a criminal act, prior to being turned over to ICE, then they may be in DOJ custody. So there's a lot of systems in play, but there are strategies that you can use to navigate those systems. As Melissa and I mentioned at the beginning, there have been a number of federal policy changes in the past 18 months or so that have been affecting immigrant communities' lives and also affecting how they're interfacing with social services. Obviously, many of you have probably seen in the media that there has been an increase in things like worksite raids. More people have been detained, more people are being deported, and those deportations are occurring more quickly than they did in the past, sometimes as quickly as a matter of days between apprehension and deportation, with no notice to a dependency court, a criminal court, or a child welfare agency who may be involved. There's also a decreased likelihood that an individual who's apprehended by ICE will be granted parole or bond. The increased risk of arrest combined with the increased likelihood that that arrest will leave you in detention for a long period of time and quite possibly deported has increased people's fears of both police and social services. And that's something that I'm sure many of you are already seeing play out, right? As we said before, in large part, this is because you don't have to be undocumented to be arrested by ICE. And when you hear people say, you know, perception is reality, that's really the experience for immigrant communities all across the United States right now. As a side note, the U.S. government cannot legally take into custody or deport a U.S. citizen, although there have been cases over many, many years in which U.S. citizens do find themselves in immigration detention and sometimes even deported and having to establish their citizenship. So pivoting back to what these policy changes are actually meaning for victims and communities. A great survey that was done by the Tahrir Justice Center last year found that 62% of legal service providers who work with survivors of violence have seen an increase in immigration-related questions. These legal service providers, 3/4 of them, have also reported that immigrants have expressed fear of contacting police and appearing in court. The LAPD, in a sort of parallel study that was released in March of this year, found that when compared to 2016, 2017 has seen a 10% drop in reports of domestic violence among Hispanics in the LA area, as well as a 25% drop in reporting of rapes. So the result of these policy changes, quite plainly, is that fear is up and crime reporting is down. Sliding down one level on this continuum of what you need to understand about immigration, we want to walk you through the process that somebody who is arrested by ICE is likely to face. At the time of arrest, there's often a lot of trauma involved. There's trauma, obviously, for the individual who's being apprehended, but quite often these arrests occur in things like traffic stops and home raids. And as a result, children are quite often present at the apprehension of a parent. A common scenario that you will hear is that immigration officials come into a house, often in quite dramatic fashion, very early in the morning, handcuff parents, take them off to immigration detention without an opportunity to console their child. We've also had reports of arrests near schools and early childhood education facilities. There is no legally enforceable requirement that says that when you are picked up by ICE, you'll have an opportunity to make care arrangements for your children, which means that we do see situations such as what we saw in Tennessee a couple of months ago with the Bean Station raid, where children are left at school or at the daycare center, essentially with the community to pick up the pieces to try to figure out where these parents are and who can take care of the children. ICE does have a policy directive on detention and removal of alien parents or legal guardians that speak to some of these issues, including the importance of letting parents make care arrangements to keep children from ending up in the child welfare system when they don't need to be there. It is applied in different ways in different areas of the country, but I do encourage you all to take a look at the directive, particularly those of you who are child welfare workers, and familiarize yourself with what the agency is willing to do. So following arrest, an individual is taken to an immigration detention facility. What does that look like? Immigration detention facilities exist all over the country, and a person can be placed at any detention facility in the country. They can also be moved from facility to facility with little or no notice of legal counsel or a child welfare worker if that's relevant to the situation. They are held in jails and jail-like facilities with little to no access to programming, including the kinds of programming often required by case plans. They have access to phones, but it can be very limited, very short, very expensive to buy a phone card. They struggle with access to attorneys, and visits are also quite difficult. And as I said before, fewer and fewer people are being released from these facilities. Unfortunately for many individuals, the outcome is that they are ultimately ordered deported. An individual who is involved in the immigration system may or may not have a hearing before an immigration judge. Some individuals who were removed years prior but allowed to stay on supervision, or who are put in an expedited process called expedited removal, can be removed without ever going before a judge. For others, it may take months or even years for their case to move through the court because of court backlogs as well as appeals. And so you may find that an individual that you're working with is sitting in a detention center for a very long period of time, and it's making it very difficult for you to support them in their case. When it's really finally time for removal, there is no advance notification provided to the individual, and often not provided to their attorneys as well. And the way the system works is that individuals are typically transferred from the facility where they're held to one of two ICE staging facilities that are located close to the border, where they're actually put on a plane. So your client may seem to ghost, to disappear in the days just prior to removal. Given the situation that families and communities are facing, there has been a lot of effort made to develop contingency plans or safety plans to, in particular, lay out financial affairs and particularly instructions for what a parent would like to have happen to their children in the event the parent is arrested by ICE. I think this is a great thing. Unfortunately, there are a lot of limitations on the legality of these powers of attorney and guardianship agreements, and in some states it's actually not possible to execute a child care power of attorney. Because of that, and just because people who agree to take care of a child may not have envisioned that that care arrangement would last for months or years, these arrangements can fall through. And this is why deportation, one of the many reasons, deportation can make children particularly vulnerable to involvement with the child welfare system, and families particularly vulnerable to dual involvement in the immigration and child welfare system. We hear about people who find a older child who's caring for younger children, who notify CPS that a child seems to be neglected. We also are hearing growing reports of children becoming homeless following the apprehension of a parent. Some children do leave the country with their parents. We find that that can depend on the child's age and their immigration status, and often whether a parent has retained their rights, for one thing legally, if there's a child welfare case or custody dispute, but also practically, can a detained and deported parent make and afford to put arrangements in place to allow family reunification outside the country? As I said, these are all ways that families become duly involved with the immigration and child welfare system. It can also be as a result of custody disputes, where an abuser turns a victim over to police or to ICE to try to get, quote-unquote, full custody of their child. Police may investigate a domestic dispute and notify child welfare. Abuse and neglect allegations can be made against parents, resulting in children being placed into foster care. And the most common scenario that we have seen so far is that families were already receiving services from child welfare, or a child was already in state care when one or both parents is taken into ICE custody. Try to imagine for a moment that you are a parent in an immigration detention system who is also involved in a dependency case. What might that look like? Well, immigration involvement, not surprisingly, would really complicate your case. You would be confused, terrified about where your children are and what's happening to them. You would find very quickly that ICE and the Child Welfare Agency don't communicate well or coordinate well with one another, and they don't really understand the limitations of the other system. You would probably find that your caseworker, even if they are working very hard to try to help you, may not know how to find you, And if they can find you, maybe sending you a notice that either you don't receive for a long time, or when you receive, you don't understand because you can't read English, or you may speak an indigenous language. You may not have access to the kind of programming and other services that the case plan says you have to complete as a precondition to getting your child back. And it may be difficult, if not impossible, for you to participate in dependency court hearings. That being said, I do just want to lift spirits a little by saying that even though reunification post-removal is really complicated, there are success stories, and we'll talk a little bit later about what those look like and how you can increase the likelihood of those outcomes in cases that you're involved with. But do know that the short-term result is that parents and children have trouble communicating. Visitation is really difficult. Case plans and court participation is difficult. And I will just note that sometimes the family court worker and sometimes social workers find that this is a very frustrating experience and that they are unable to figure out how to work towards reunification and sometimes not willing. So unfortunately, with these families who are duly involved in both systems, we often see one of two outcomes. One is de facto separation, where a parent is deported and either the children are unable to join that parent in the country of origin or choose not to join them, or we see the even more concerning scenario where parental rights are actually terminated. Obviously, as you've seen, the stakes are incredibly high for any family, but when domestic violence is a part of the case, the stakes for children and families are even higher. And I will turn it over to Melissa. Yeah.
Thank you, Emily. So now that Emily has helped us understand a little bit better about the experience of immigrant parents dually involved with child welfare, we're going to take a look at what it means to be an immigrant victim of domestic violence. And clearly, in 90 minutes, today's webinar cannot and will not take the place of intensive training on domestic violence. I know a number of you present today are domestic violence providers, and those of you that are not, if you have not yet sought out training, extensive training on domestic violence, I really encourage you to do so. I worked as a legal services attorney in a variety of different settings for a number of years, and it was not until I came to the council that I truly understood the dynamics of domestic violence and how it impacts families and how it impacts decision-making by victims that are particularly involved with the child welfare system. So again, we're going to give you a quick 30,000-foot view of sort of what is domestic violence and what are some of the unique challenges that face immigrant victims of domestic violence. But please, I do strongly suggest that you go out and seek more training on this topic if you're not yet fully aware of how things work, because it's a really complicated dynamic. So first off, let's just start with what is the definition of domestic violence. So I like to use this definition that comes out of the Council's checklist to promote perpetrator accountability in dependency cases involving domestic violence. And the reason that I like to use it is because it really touches on all of the different important facets of domestic violence. Domestic violence is often referred to as intimate partner violence. And it's not simply an act of physical or sexual violence. What it is, as this definition states, is a pattern of assaultive and coercive behaviors that operate at a variety of levels. So yes, the violence can be physical, it can be sexual, but it can also be psychological, emotional, financial, and we'll talk about some of the specific ways that this plays out. One really important factor to remember is that domestic violence is a pattern of coercive and controlling behavior. It is not the result of an isolated, angry, or violent episode. It is a calculated pattern of achieving power and control over another. And the reason that this is really important is that oftentimes when workers don't understand the dynamics of domestic violence, what will happen is that they will refer batterers to anger management classes. And really, domestic violence in its truest form is not about anger management. It's a calculated, often very calm pattern of coercion and control. And so really what agencies and providers need to do is refer batterers to batterer intervention programs that can truly help batterers address the challenges that they face and the reasons that they behave the way that they do. Another reason it's important to look at this definition of domestic violence when working in the child welfare system is, again, oftentimes child welfare workers will, with the best of intentions, refer partners that are involved in a violent relationship to couples counseling. Again, domestic violence is a pattern of coercion and control. So couples counseling seeks at working on the relationship and the faults of each of the parties. But when you have domestic violence, it's really not appropriate to send a victim into a couples counseling when she doesn't, and I say she because 85% of victims of domestic violence are women, but obviously a large and terrible number of men and women are victims of domestic violence. So I use the term she, but please understand that that is not in any way to discredit the experience that male victims of domestic violence have. Obviously, it's terrible for everybody. So that's sort of the quick overview and the definition. If you haven't seen this before, this is the power and control wheel. I use this because it's provides a really good illustration of sort of this pattern of coercion and control that we just talked about in the definition. This wheel was developed by the Domestic Abuse Intervention Program in Duluth, Minnesota, many years ago, and it has actually been modified a number of times. If you Google power and control wheels, you'll come up with all sorts of different wheels. There's an immigrant control wheel that we'll see in a bit. There is an LGBTQ wheel. There's an elder abuse wheel. There are tons of them out there, and I would implore you to go out and find them and take a look, because these patterns of coercion and control do vary depending on the relationship between the parties. And if you take a look at this wheel, what it does is it does show domestic violence as obviously physical and sexual violence are a main part of domestic violence. But you see the different spokes address all of the different ways that batterers can achieve power and control aside and apart from exerting physical or sexual violence. And so they can use coercion and threats, intimidation, emotional abuse, isolation. Batterers will often minimize their behavior, deny the behavior, or even blame the victim for their behavior. Batterers will often use children against the victim, making them feel guilty about the children. We run into this whenever child welfare becomes involved. This is a really important facet of the pattern of coercion and control. This Duluth model was based on domestic violence as a gender-based form of violence. And so here it shows using male privilege as a means of power and control, also economic abuse. So basically what this shows is that, yes, you often do see physical and sexual violence, but oftentimes batterers do not need to use physical and sexual violence to continue to exert their control. So what we see is oftentimes it's enough for a batterer to have one extreme episode of physical or sexual violence, and that's enough. After that, all they need to do is use these different forms of pattern and control to keep a victim in a state of fear and be able to manipulate them. So it's important to look at this, understand that it's more than just physical and sexual violence, that there's a lot more going on that explains sort of batterer behavior and victim responses. So why do we care? Because domestic violence is really, really, really common. It's much more common than people realize. Nationally, 1 in 3 women and 1 in 4 men are victims of domestic violence. When we talk about immigrant victims of domestic violence, that number rises disproportionately. We know that Korean women experience domestic violence at a higher rate, 30 to 50%, Latina women at 50 to 60%, and that number is even higher in research done on Filipino, Indian, and Pakistani women. We also know that abuse rates rise when U.S. citizen men marry immigrant women, particularly when the immigrant women are undocumented. And the reason for that is when you think back to the power and control wheel, they have that much more of an advantage in terms of exerting control and keeping their victim under their thumb. So when working with immigrant victims, in addition to the statistics we just looked at on prevalence, we also know that immigrant victims of domestic violence stay longer with their batterer, that they tend to have fewer resources, and that they sustain more severe physical and emotional consequences of abuse. So why is it that immigrant victims stay longer despite the more severe abuse? The number one reason that non-citizens stay with an abuser is out of the fear that they will be deported. And that's why Emily and I have come together today to talk about this, because there are so many challenges when you're working with immigrant families involved with child welfare. And there are so many challenges when you're working with immigrant victims of domestic violence involved with child welfare. And when you put those two areas that have traditionally been very siloed together, what you have is a really, really sad and challenging case that many providers are just not qualified to handle. And so we want to use today to give you a little bit more information about how we can help non-citizens in particular, but all immigrant victims of domestic violence that become involved with child welfare. So we know that undocumented immigrants stay longer because of their fear that they will be deported. But there are other reasons. First, abusers often threaten to have the victim deported and threaten that they'll obtain custody of the children, that they'll never see them again. Non-citizen survivors are often prevented from learning English. They're cut off from their family in their home country, and they're kept from others who speak their own language. Abusers threaten with frequency to call ICE and have the children or the victim deported if they call the police and report the abuse. Non-citizens that don't have work permits are often completely dependent on their spouse's income and are not in a position to support themselves by obtaining legal employment. When abusers control a victim's immigration status, so that is to say that an immigrant is relying on their partner to file a petition on their behalf to become a legal permanent resident, 72.3% of batterers never file the paperwork that they say they're going to file. Those that do delay for an average of 4 years before filing the paperwork. One thing that I have found in working with immigrant victims of domestic violence is that they've told me that they stayed and they didn't share the abuse with others because they were embarrassed that they had picked an abusive partner or that they held themselves responsible for the abuse. And if you think back to the power and control wheel, that's because they're being told that it's their fault, or their partner is often minimizing or denying the abuse. Also, oftentimes victims, like professionals, don't really understand what domestic violence is, and they often feel like they're not victims of domestic violence unless excessive physical or sexual force has been used. But like I said, there are many, many ways that a batterer can abuse their spouse that don't necessarily involve physical or sexual force. Many immigrant victims are not aware that there even are legal forms of relief available to them, including protection orders and some of the immigration relief that we're going to talk about today. So part of this is, part of the key here is educating professionals like you on what options are available to immigrant victims of domestic violence so that we can help make sure that they are able to take advantage of those services. And as Emily talked about, and particularly in the last 18 months, immigrant victims are really reluctant to go to court or to social services to seek assistance. They're understandably and rightfully very concerned that they may arrive at the courthouse and find themselves deported. So this is the power and control wheel that was created by Futures Without Violence. And what it did was it modified the Duluth power and control wheel and created a specific wheel that looks at control and power tactics used with immigrant victims of domestic violence. So as you can see, the wheel does a really nice job of capturing all the different ways that batterers are able to exert power and control over immigrant victims, some of which we just talked about a little bit. Again, by using their immigration status, lack of community, inability to speak English, other immigration-related challenges against them. So let's take a look at some of these. Again, like with all domestic violence relationships, there's always the possibility of physical and or sexual abuse. This can come in a number of different forms. It can come in pushing, shoving, hitting, slapping, choking, pulling hair. These are all outlined on the outside of the power and control wheel. And I think what's important to remember is that those are the obvious ones, right? Those are the ones that somebody says, my partner did this to me, and somebody else can easily say, I think that you are in an abusive relationship. And so it's really important as professionals that we not ask only whether there has been physical or sexual abuse, because those are the easy ones, those are the obvious ones. But we need to dig deeper. We need to be looking very specifically at what the relationship looks like within the couple. And so when you're dealing with immigrant victims of domestic violence or women who may be victims of domestic violence, you should be asking more questions. So isolation is a really, really powerful way for victims to exert power and control, or for batterers to exert power and control over immigrant victims. And this is very common. What they often do is isolate them from their family and their friends. They keep them away from anyone who speaks their native language. They don't allow them to learn English. And what this does is keeps them in a position where they're really not able to leave. Emotional abuse as well. Oftentimes, batterers will lie about their spouse's immigration status. What I've seen a lot is that batterers will say, oh, yeah, I filed that paperwork last year. We're just waiting for it to come back. But in fact, as we saw earlier, they didn't file it. And they may have no intention of filing it. And on average, if they do, it's going to be 4 years before they do. Or if they have filed it, then they'll often threaten to withdraw the paperwork and withdraw the petition. And if there are children involved, then what that does is put a parent in a position where they're constantly in fear of being deported or removed from the country. Emotionally, batterers will often tell lies about their partners. They'll degrade them to friends and family. They'll use racist terms. What I found a lot when I was working at legal services on these cases is that my clients would tell me that their partners would refer to them often as mail order brides. Tell them that they were nothing more than a mail order bride and that they had no purpose other than to serve their spouse. And they heard this day in and day out. Obviously, economic abuse, we talked a little bit about that. If an immigrant does not have work authorization or the ability to work legally, then they find themselves completely dependent on batterers for their finances. Oftentimes, batterers will retain complete control over the bank accounts and will not allow their spouses to get a job, or if they do, they'll threaten to report them for working under the table if they don't have work authorization. They'll also keep them from going to school or getting job training, again, so that they're not in a position to become independent. Oftentimes, batterers will use children. And this is really what I found in working with my clients. What I found was that this was the hot spot, right, where parents want to be with their children, they want to protect their children, and so batterers who threaten their immigrant spouses or partners to have them deported or have the children deported or separate them from their children, that's a really effective battering tactic. And so what you find is that women in particular are willing to stay much longer if they feel like leaving or reporting the abuse would result in losing their children. Again, we've talked about threats. Threats can come in all sorts of different forms, but the most common one when working with immigrant victims of domestic violence is that they will call INS and have them deported. And it's important to remember, like Emily touched upon earlier, that this doesn't just apply to undocumented immigrants. All immigrants who are non-citizens face the possibility of deportation. And so this threat can be really powerful regardless of whether an immigrant has legal immigrant status. and it is used against them. And oftentimes, like I said, immigrants don't truly understand what their status is. Even those of us that work in the field find it hard to always understand what immigrant status means. It's very complicated. It's changing daily. And so if you imagine being an immigrant and having your spouse or your partner tell you constantly, I could have your status taken away tomorrow if I tried, unless you're an attorney practicing in the area, you'd be hard-pressed to not believe them. And so that's a really effective strategy for maintaining power and control. Again, in a similar vein, oftentimes batterers will rely on their own citizenship or their residency privilege, saying, that they're in the position of power, and that really if their partner does not obey them, then they have complete power over what happens to her. Intimidation. So one common tactic that we see is that batterers will hide or destroy important papers. So they will tear up or otherwise destroy an immigrant victim's passport, birth certificate, ID cards. And this is really important and relevant because, as we're going to talk about in a bit, if an immigrant wants to file for a form of immigration relief that's available to victims of crime and victims of domestic violence, then they have to have access to all of this important paperwork. And so if a batterer hides that paperwork or steals that paperwork, then what they've done is effectively made it that much more difficult for a victim to obtain legal status as a victim of crime. And so that is something that you see often that might not seem that significant to those of us that are U.S. citizens that can just drive down and get a new copy of our birth certificate. But oftentimes immigrants, especially when working with older immigrants, are not able to get a replacement birth certificate or replacement passport easily. And so those are the types of behaviors that really are incredibly effective and powerful that don't apply to non-immigrant victims of domestic violence. So what we'd like to do is take a little bit of time to take a look at what it actually feels like to be an immigrant victim of domestic violence before we go into how professionals involved with child welfare can actually improve practice and improve the experience for victims. So what we're going to do is go ahead and read through a hypothetical case to you, and we're going to ask you to answer questions by way of our interactive survey tool. And so in the same way that you did when you first signed on to the webinar and you told us sort of who you are and where you've come from, we'd like you to listen to our hypothetical, and then when we ask a question, go ahead and share your answer. There is no right or wrong answer necessarily, so please be honest. Also, it's completely anonymous, so again, please be honest, because our hope is that this will sort of give us a sense of where you are and spark the conversation and help sort of guide where the second half of this conversation goes. So, imagine that your name is Maria, and you came to your name is Rosa, and you came to the United States from a small village in El Salvador 4 years ago with your daughter, Roberta. You and Roberta have lived together in the United States continuously since that time. You fled El Salvador when Roberta was 12 years old because she was being targeted by a gang member in El Salvador who was set on making her his girlfriend. You were terrified for your daughter's safety, and you hired a coyote to bring the two of you to the United States for a better life. You and Roberta are both undocumented. You do not speak English well, but Roberta has become quite fluent as a result of attending public school here. 1 year after moving to the United States, you met your husband, Jose. You have 2 children with Jose, a daughter, age 2, and a son, age 6 months. Jose is a U.S. citizen. You clean houses to make extra money while your husband picks up the children from school and cares for them. Today, your husband calls your cell phone every 15 minutes from noon until 3 p.m., leaving messages saying, "You'd better get your ass home before I do, or you're going to be sorry. Don't test me." You know from past experience that it is not going to be a good night for you. He's so upset that you tell your boss you cannot help her today. She warns you that as a result of the constant calls from your husband while you are working, you are on thin ice. She's thinking of finding somebody else to help her, as there are plenty of women like you that would be happy to get this kind of under-the-table work. She reminds you that you don't even speak English. Do you stay at work or do you go home to your husband? Okay, we're going to give about 5 more seconds for you to answer, and then we'll move on. Okay, so it looks like about 41% of you said that you would go home. 6% would stay, and 8 are not sure. So this is a really complicated and difficult decision. Again, there's no right answer, but these are the types of decisions that immigrant victims of domestic violence face on a daily basis. Undocumented immigrants of domestic violence, like we talked about, are often financially dependent on their abusers. Like in this case, if she loses this job, she doesn't have work authorization. She doesn't have the ability to find another job. If they do work, they're often worried that they'll lose their job and that they won't be able to find other employment, just like she feels. Even documented workers with lawful employment report that they feel discriminated against by their employers who make them work harder, for longer hours, and for less pay. And they report that they worry regularly about losing their job. So I would imagine that those of you that decided to stay at work were concerned about losing your job. Those of you that decided to go home were concerned about the abuse that you would face if you didn't go home. And these are the impossible decisions that victims of domestic violence are having to make on a daily basis. So let's assume that you decided to stay at work, since you and Jose are barely making ends meet for your 3 children as it is, and you don't know whether you could find another job. As a result, you get home after your husband. He yells at you and tells your kids that you're a putana. He tears up your wedding pictures and your wedding certificate. He hits you so hard that you fall and hit your head on the counter. You have a large gash in your head that is bleeding heavily. You reach for the phone to call the police, and Jose laughs, telling you to go ahead and call them. He tells you he'll call the police and have them call ICE and have you and Roberta both deported so that you'll never see the younger children again. He says he'll be happy to see Roberta taken as a puta to serve the gangs in El Salvador, as she's good for nothing anyhow. All 3 of your children witnessed this incident. Do you call the police? Do you seek medical treatment? Okay, about 10 more seconds to answer and we'll get going. Okay, so I would say that this is probably a pretty accurate representation of what the reality is for immigrant victims of domestic violence. 61% of you said that you wouldn't call the police. 27% said yes, and almost 12% were unsure. The results were different, though, in terms of whether you seek medical treatment, with 52, almost 53% saying yes, you would, and 35 saying no, and again, almost 12% not being sure. So what we find in reality is that even when immigrant survivors are severely beaten by their partners, they are reluctant to call the police or to seek medical treatment. So this is due in parts to threats by the batterer that he'll call ICE and law enforcement and report the victim's legal status, even if documented, and have them deported. And this is partially out of distrust for the system. And as Emily talked about a little bit earlier, what we found in the last 18 months or so is that distrust in the system, distrust of law enforcement has increased. And so reporting of incidents of crime and domestic violence in particular has gone way down. So this poll that indicates that 60% of you would not call the police is really an accurate representation of what's happening. Unfortunately, the downside of this is that crime enforcement efforts are really hampered when victims and witnesses are not comfortable seeking the assistance of law enforcement in the courts. And so when incidents like this go unreported, law enforcement is not able to follow up and prosecute batterers. And so the results of this is that it actually just continues to give batterers in cases involving immigrant victims that much more ability to exert power and control.
So let's take this difficult story one more step from the point where being undocumented and being an undocumented victim of domestic violence can also become an impediment to preserving your parental rights. Assume that you have decided to leave Jose. You still have your house cleaning job and you're staying with a neighbor. Your neighbor encourages you to get a restraining order against Jose. You obtain a temporary restraining order and have a hearing scheduled in a week for a permanent order. Your husband calls you to tell you that he was served notice of the permanent protection order hearing. He tells you that you are an illegal alien with no rights in this country, and that if you show up for the hearing, La Migra will be waiting at the courthouse to take you away, just like they did to that woman in Texas that you saw in the news. Do you go to the hearing for the protection order? We'll give it about 5 more seconds to vote. Okay, so it looks like more than half of you would not go to the court hearing, which is really no surprise considering what we have been talking with you about in terms of people's fear of police and courthouses. And to be quite honest, it is also reflective of the concern that undocumented individuals in particular should have, unfortunately, when stepping into a courthouse for any reason. Officially, ICE's policy on courthouse arrest states that the agency will arrest persons in courthouses whom they believe to be removable from the U.S. But the policy goes on to state that they generally will not arrest other undocumented persons, such as accompanying family members of the targeted individual and those serving as witnesses. The policy also states that ICE will generally not conduct enforcement in areas of courthouses that are dedicated to non-criminal matters, such as family courts. That being said, over the past year, we've seen a notable increase in the number of arrests happening at courthouses, including of individuals seeking protective or custody orders. And abusers are using this fear and this reality as another threat to maintain power and control over their victims. So let's assume that you obtain the extended protection order against Jose, and after the hearing, he beats you up outside the courthouse. Roberta tries to intervene, but she falls and gets hurt. A bystander calls the police, who take both you and Jose into custody. Jose is released a few hours later, but police keep you in custody because there is an ICE detainer, an agreement between the local law enforcement agency and ICE. You were sent to an ICE detention center out of state. All 3 of your children are taken by CPS, and you're instructed to meet with the child welfare worker the following day at 2 p.m. to discuss Roberta's placement, but you cannot attend because you're in immigration custody. Should your lack of participation in that meeting be used against you at the dependency hearing? We'll give it about 5 more seconds. Okay, so I'm really excited about the results of this particular poll because it looks like almost 95% of you felt that your lack of, or that Maria's lack of participation should not be used against her. That's great. That is the ideal outcome that Melissa and I are trying to educate practitioners on, because in fact it shouldn't be, but that's not always the situation in reality. Detained parents don't always know that their children have been placed in the child welfare system. That's the first problem. Reasonable efforts include locating the parent and keeping them informed about the case in a language they understand. But as we talked about earlier, while ICE has policies that address detained parents' need to communicate with their children and participate in case plans and dependency hearings, the policy doesn't guarantee that parents can do the things that are often required of them by child welfare, because the agencies don't communicate and coordinate well, because visitation is so difficult, because detention centers don't provide the kinds of services and programming that's required. So it's important, and it seems like many of you already understand this, that child welfare entities be flexible with parents. There are other things that parents can do to show their desire to reunify with their children, and we'll talk a little bit more about them in the final section of the training.
So the CPS worker speaks to your preschool teacher, your neighbor, your husband, and Roberta, and decides to file a petition for removal. ICE refuses to help you participate in the court hearing, where the court hears evidence of your past drinking, depression, your current detention, and the possibility that you will be deported, as well as your inability to comply with the case plan while you are detained. The court agrees with CPS that it is in the younger children's best interest to be placed with their father, because he has stable housing and lawful employment. The court concludes that because you are no longer in the home, the domestic violence is not relevant to the placement decision. Jose refuses to take Roberta, so CPS places her with a foster family, and a case plan is established. Is CPS required to provide reunification services to you if you are in detention? Yes or no? So we'll close the poll in about 5 seconds. So the reality is that even undocumented immigrant parents have rights in dependency court. And so the answer to this one is yes. CPS is required to provide reunification efforts and reasonable efforts to reunify to all parents, even if they're in ICE detention. When an immigrant victim of domestic violence is involved in a child welfare case, Child Protective Services must reach out to other professionals for help in a collaborative manner. it may be a little bit harder. It may not be in the same boilerplate case plan that they generally use. Social services should, in these cases, be reaching out to domestic violence advocates, other child welfare professionals, immigration professionals, legal services providers, immigration enforcement agencies if the person is detained, and any others that are appropriate based on the facts of the case. There's not currently enough conversation happening between the immigration courts and the child welfare system, but it is incumbent under the Adoption Safe Families Act on child welfare services to provide reasonable efforts to reunify. And that will include, in a case like this, providing telephonic access to all court hearings, trying to arrange phone meetings and visitation, providing interpreters and translating any relevant documents, and providing this victim of domestic violence with any other efforts that are reasonable given the circumstances.
You appear before an immigration judge and tell him you're afraid to go home and you are afraid of your husband. Your asylum application is rejected because you didn't file within the first year you were in the U.S. and you can't prove that circumstances have changed in your home country. You're eligible for relief based on the domestic violence, but you can't afford to pay an immigration attorney and you're not able to navigate the case without help. You tell the judge that you're worried about your U.S. citizen children, but you're ordered deported anyway. Will you be able to reunify with your children now that you have been deported? Okay, take 5 more seconds for both. I saw some waffling on the voting on this one, which isn't surprised. It was an intentionally unclear question designed to make you think. And we probably should have asked, will you be legally able to reunify with your children, or will you be practically able to reunify with your children? And sometimes those are two different things. So the law requires reasonable efforts be made even when a parent is outside the United States. And detention and deportation alone are not grounds for termination of parental rights, which is something that, unfortunately, a lot of child welfare workers don't know. But you should never assume that a parent is unfit or unwilling simply because they've become involved with the immigration system. We've talked a lot about thinking creatively, about modifying case plans, and based on the results to a few of these earlier polls, it seems like most of you on the line are already doing that, which is fantastic. If the state allows it, you can also encourage flexibility with the termination timeline, which can be the difference between a parent being able to reunify and termination in some instances. And unless the parent objects, you can reach out to the consulate of their country of origin, who can help you connect with and work with the local child welfare agency in that country to deal with home studies and other preconditions. Most importantly, I think the thing to remember is that just because the standards of living in a parent's country of origin may differ from those in the United States, it doesn't make that reunification inappropriate for the child involved.
So now that we've talked about what it is to be an immigrant and an immigrant victim of domestic violence, we want to turn to how do we improve the experience for immigrant victims who are involved with the child welfare system. So when I was preparing for this webinar, I did a Google search and I found these bullet points on the Santa Clara, California Dependency Court website. And I thought that they were really telling because they really do encompass, I believe, the purpose behind dependency courts across the country. dependency courts and the people that work in the child welfare system have the best of intentions, and that is to help families and to help children. I have no doubt about that. I do think that many of us professionals come to these cases with different experiences and different viewpoints, and that's why collaboration is so important. But let's look at these bullets, because these are sort of standard bullets, standard policies behind dependency courts. So number one, to protect children, okay? To give them stability, to keep families together, to treat everyone with dignity, to respect diversity, and to value every child like their own. But there's a disconnect between these policies for the dependency court system and what's happening in terms of the immigration enforcement system. And so what we're finding is that folks that we are asking to rely on the court system for protection through dependency cases or protective orders are afraid to do so because of fear of immigration enforcement. So I don't know if you remember, but this Washington Post article came out quite a while ago. And what it was information about a female citizen of Mexico living in El Paso that went to the courthouse from her domestic violence shelter with her advocate. And she was picked up by ICE outside the courthouse where she was seeking a protective order against her abusive boyfriend. The woman had no outstanding warrants. There was no reason for her to be detained other than it appeared that her batterer had called ICE and informed them that she would be at the courthouse that day. We've seen a lot of headlines like this over the last couple of years, and as we've talked about, the not surprising result is that individuals are fearful and distrustful of the systems that are seeking to protect them from abuse. So what does this mean for professionals that are working in the dependency court and that are trying to achieve the policy principles that were outlined in the previous slide? The reality is that immigration enforcement is making it harder for dependency courts and other systems to do their jobs. Like I said, we're encouraging people to go to court to seek protections, but they don't feel safe doing so. And so this is a really problematic new trend that we need to address. So what can we do? What can we do to help immigrant victims of domestic violence that need the support of the child welfare system and the dependency courts in order to become independent and escape an abusive relationship? So in the language of the Adoption Safe Families Act, what we're going to talk about for the rest of this webinar is what reasonable efforts should child welfare services be providing to reunify for immigrant victims of domestic violence. And so while we talk about this from the standpoint of child welfare workers and what reasonable efforts they could be providing, this is also relevant to those of you that are domestic violence advocates, that are legal advocates, that are helping these individuals from in other areas, other professions, because you can also be demanding that social services make reasonable efforts given the facts of the case. So where do we begin? Child welfare services should always understand and consider the consequences of any requested findings or orders. So this is really important because when a child welfare case opens, they seek certain findings against the parents and they seek orders of the court. And so it's really important to remember that findings of abuse and neglect can be used against an immigrant parent in deportation proceedings down the road. So one thing that we talk about a lot in the domestic violence field is that victims of domestic violence are not by nature or necessarily without more abusive or neglectful. And so mere exposure to domestic violence should never support a finding of abuse and neglect against a parent. If a victim parent has a finding of abuse or neglect, there really needs to be actual abuse or neglect. Otherwise, what social services should be doing is looking at ways to keep the victim parent together and safe with the children, and instead to remove the batterer and seek a finding of abuse and neglect against the batterer. This is really, really important when working with immigrants because these findings can be used against them later in removal proceedings or as a means of denying a petition for immigration relief as a victim of crime. And although we're talking specifically about child welfare cases today, it's also important to remember that protective orders related to domestic violence can also be grounds for removal. And so oftentimes workers will require victims to seek a protective order against their abuser. And this may be a great idea, but it may be really, really dangerous as well. Oftentimes, and in certain states, abusers are then allowed to come back and seek a protective order against the victim. And so it's important to remember the impact that such a protective order would have on the victim, again, in terms of removal proceedings, or perhaps it could be used against that victim later on if trying to stay in the United States under VAWA or a U visa. And I included this here. We're going to talk a little bit about special immigrant juvenile status, but special immigrant juvenile status cannot be sought without certain findings and orders of a state court, including a dependency court. And so I list those here, but it's really, again, important to understand if you are seeking or making findings or orders that these can have huge implications on immigrants down the road. It's also essential that any case plans or service agreements take into account a parent's immigration status and culture. So this means that social services needs to be translating all court reports, any other documents, including health and school records, into the parent's native language. It's not okay to have a child translate for a parent. I can't tell you how many times in my practice my clients, who were the children in the foster care system, were asked to translate court reports and documents for their parents by social services. Any time that social services is involved or the court is involved, they should be using certified interpreters to do proper translations and provide interpretations. Something else that I saw a lot of was that parents would be ordered to attend parenting classes or therapy or other services, but then they wouldn't be provided in the parent's native language. Or if they were, then they would have to wait 8 months to get in to see a provider in their native language. So these are not reasonable services to provide to individuals with limited English proficiency or who do not speak English. It's also really important that you not require parents to ever comply with plans that are at odds with their culture. So where I saw this play out was often when parents with substance abuse issues were ordered to faith-based substance abuse programs, and yet their own religion or culture was at odds with the faith that ran the program. Those are, again, not reasonable efforts. Those are not reasonable expectations. And one thing that I can't believe that I saw, but that I did see and that I hope is happening less these days, was that sometimes I would see case plans for undocumented parents that required them to obtain legal gainful employment in order to reunify with their children. And obviously this is impossible and therefore not reasonable. And so it's just, and I think, again, it wasn't out of malice. I think it just was that oftentimes social workers would have a boilerplate case plan that they would use, and they didn't necessarily think it through. And so it's so important to take trainings like this and to make sure that you're approaching each of these cases looking at the facts of the case and the needs of the parents and make sure that it addresses their actual needs reasonably. And then offer appropriate services. And I included this here. We talked about it a little bit earlier, but if you're working with victims of domestic violence, then you need to make sure that your services are appropriate for that client.
So I think we've talked a lot through the scenario about the different kinds of things that child welfare workers can do to take into account the realities of detention and deportation. I think one of the biggest points that I want to reemphasize, right, is that being taken into immigration custody is not in and of itself abandonment or neglect of a child, but we have seen cases, unfortunately, where courts have found that to be true or have found that a parent is unfit purely by virtue of being undocumented. And so I think it's really important to keep dispelling that notion, particularly in a situation where the only reason a family is involved with the child welfare system is because they became involved with the immigration system. Not to do so is sort of a perversion of the intent of the child welfare system in and of itself, and that makes it even more critical that CPS workers be looking for ways to reunify and to offer pathways to reunification, as Melissa said, that really work for the families involved. Working with the consulates is critical in an increasing number of states and localities. There are MOUs being signed with the consulates that trip anytime a child with an undocumented or a non-citizen, rather, parent comes into immigration custody to help with the collaboration with, for example, the Child Welfare Agency in the parent's home country and the search for kinship care options both in the U.S. and outside the U.S., both with citizen, non-citizen, and undocumented individuals. Those creative means of visitation are being used and they are working, things like Skype, including Skype participation in courts when the court will permit it. And the final key point, I think, is really thinking about the long-term outcome for the child and what that might require. It's critical if the case plan is aiming for reunification outside the United States, you really want to be taking actions as soon as possible to make sure that a child has the documentation that they're going to need to move to and to successfully integrate in the parent's country of origin. In many countries, if the child's birth is not registered with the parent's home country, that child will not be able to access the education system or the healthcare system. In many instances, although you obviously need to check with the individual consulate in each situation, but in many instances, registering a child's birth with the parent's home government does not in any way affect the child's citizenship. You also need to make sure that U.S. citizen children have passports so that they do have the widest possible range of opportunities to come back to the United States if and when they or their parents decide that that's the appropriate outcome for them. A lot of this, as I intimated before, is starting to take shape in the form of local task force models. The most solidified one is a task force that has developed in Tucson and Nogales, Arizona, with their counterparts in Nogales, Mexico, and it's a partnership of the dependency courts, the child welfare workers, the Mexican consulate, DIF, which is the Mexican Child Welfare Agency, immigration attorneys, and child welfare experts who have figured out how to build relationships so that they don't have to start fresh with every single case to figure out how they're going to best serve that family with the goal of permanency for the child. If anybody would like to know more about the Tucson model, feel free to reach out to me offsides, and I can either connect you to the folks down in Tucson or can answer some initial questions yourself, but it's something that I really would encourage you to think about in your local area, particularly if you are in an area with a large immigrant community. The other thing that many of you on the call, whose answers really reflected a deep bench of knowledge on these sorts of issues already, can be involved in is helping to develop training for child welfare workers on best practices for serving dually involved families, in particular to try to address some of those biases that I hinted at before, where courts have in some cases found that a parent is unfit by virtue of being undocumented.
So last summer at the council, I conducted a listening session with immigrant survivors in my own community that had been involved with the child welfare system. And I asked them to identify the greatest challenges that they faced when they had to work with the child welfare system. So in addition to sort of the obvious areas that we talked about in the last few slides, this slide shows some of the themes that came out of my conversation with them. And as you can see, it quickly became clear that immigrant victims of domestic violence that were involved with child welfare really needed a really wide range of assistance to become truly independent from their batterer. And so it's incumbent on social services to make sure that they help provide these services to immigrant victims of domestic violence to help them as part of the obligation to provide reasonable efforts to reunify. And so these services are more than just parenting classes and therapy. They should really be looking at helping them obtain employment, education, health benefits, government benefits, and housing. These are all challenges that are everyday realities and challenges for immigrant victims of domestic violence that they need in order to truly become independent. But according to the women that I spoke to, and certainly as I found in my practice, the number one most helpful form of assistance that they provided was the last one on this slide, which is referrals to and legal assistance for obtaining protection orders and immigration relief. And so we're going to talk about quickly, again, just a quick overview. We're not going to make any of you immigration experts, nor are we the immigration experts in terms of the folks doing these cases, although if you reach out to us, we can certainly help try to find your local experts in these areas. But one of the ways that all of you, every single professional that has signed on to this webinar today can help is to identify when a victim of domestic violence might qualify for a certain form of legal immigration relief, and make sure that you are making referrals to the proper legal services or other immigration professionals that can help with that. So the main ones we're going to talk about today include the VAWA self-petition and cancellation of removal, which are available to certain abused spouses, children, and parents. The battered spouse waiver for abused spouses that have a conditional legal permanent resident status, the U visa for victims of crime, and the special immigrant juvenile status for youth that have been found abused, neglected, or abandoned by one or both of their parents. So the VAWA self-petition is the form of immigration relief that you probably hear about the most when talking about victims of domestic violence. VAWA self-petitions are one of the only ways that immigrants can seek immigration status without the support of another, whether it's a spouse, an employer, or some other entity or person. To do so, a victim of domestic violence files a Form I-360 with supporting evidence that establishes first that the victim has what is known as a qualifying spousal relationship with the abuser, or is the parent or child of the abuser, that the victim has resided with the abuser, that the victim is a person of good moral character, and that's where we worry about certain findings of abuse or neglect or domestic violence findings that can impact that particular prong. And finally, that the victim suffered batter or extreme cruelty by the citizen or lawful permanent resident abuser. Although an immigration expert should prepare and file this petition, social services providers, domestic violence advocates, and any other professionals working with immigrant victims of domestic violence can be incredibly helpful when it comes to obtaining all of the evidence required to prove these different elements. So when I worked these cases, I spent an immense amount of time gathering and putting together this information. And one way that social workers can really help immigrant victims of domestic violence is to help them gather the evidence, including obtaining new birth certificates, like in our case hypothetical, where he tore up their marriage certificate. That's the type of thing that they would need help finding a new marriage certificate to satisfy the marital relationship prong. And social workers and other professionals can make referrals to attorneys or immigration experts that can help with the case. So unlike the VAWA self-petition that we just talked about, the VAWA cancellation of removal option is designed to stop removal proceedings that are already underway. So in order to stop these proceedings, victims of abuse must prove that they or their child have been subject to extreme cruelty or battered by a citizen or lawful permanent resident spouse or parent, that they've lived continuously in the United States for the 3 years prior to the application, that they have good moral character, and that they're not otherwise inadmissible, deportable, or have been convicted of an aggravated felony. And then there is this additional prong that requires that they show that removal would result in extreme hardship to themselves, their children, or their parents. So this last element is really the hardest prong to prove. It's not required for the VAWA self-petition. And whether an individual qualifies under all of these elements really depends on the specific facts of the case and the evidence that they're able to gather. So again, it's so important to make sure that if an immigrant victim might qualify for this, that you as professionals working with that person make the appropriate referrals to a legal services or immigration attorney or other person qualified to help with these. So the battered spouse waiver is not something that folks hear a whole lot about. It is something that I came across in my practice as a legal services attorney. And what it is this comes into play when an immigrant has actually been lawfully admitted to the United States pursuant to a petition filed by their spouse. So in those cases, immigrants receive what's called a 2-year conditional green card. And so in that 2 years, that lawful permanent resident status or green card can be removed if it appears that the marriage was entered into in bad faith or for a number of other reasons. So at the end of the 2-year conditional period, spouses generally file what's called a joint petition to remove the conditions on the green card, and then they are granted a 10-year green card for their lawful permanent resident status. So for victims of domestic violence, immigrant spouses may seek a battered waiver spouse. And what this does is it waives the requirement that they file a joint petition with their spouse to remove the waiver. And so although this doesn't apply in a lot of cases, this is a really important option to be aware of for immigrant victims that are here on a conditional, 2-year conditional green card. So then we have the U visa, and the U visa, unlike the VAWA petitions and the battered spouse waiver, was not created specifically and only for victims of domestic violence. So unlike the 3 other forms of relief that we've talked about already, U visas are available for any immigrant victims of what is referred to as a qualifying criminal activity. And so there are a number of different criminal activities that qualify for a U visa application, and domestic violence is included in that list. So this is a really important option. And the reason that it's really important for professionals to familiarize themselves with U visas is that U visas are the only option for victims of domestic violence who are not or have not been married to their abuser. So if you'll remember, the other 3 options were for individuals that could establish a good faith marriage. And so this option is available to those who cannot establish good faith marriage if they can establish all of these other elements that you see on the slide. So here is a list of the U visa certifying agencies. So these are the different agencies that are able to certify. And I'm actually going to, sorry, I'm rushing a little because we're running out of time, but I do want to go back and go through these. So for U visa eligibility, the applicant must prove that they're a victim of a qualifying criminal activity. In this case, we're talking about domestic violence, that they've suffered severe physical or mental abuse as a result of that criminal activity, that they have information about the criminal activity, and that they have been, are being, or are likely to be helpful in the investigation or prosecution of that criminal activity. The crime must have occurred in the United States or have violated the laws of the United States, and the applicant must be admissible or qualify for a waiver of inadmissibility. So these are all terms for an immigration attorney to worry about. But basically, the purpose of the U visa option is that we want victims of crime to help prosecute those crimes because we want law enforcement to be able to put a stop to those crimes. And so what this does is it incentivizes victims to step forward and be helpful in the investigation or prosecution of a crime. And so these are the elements that must be proven. And part of the application requires a Form 1918B to be submitted and signed by a certifying agency that basically attests to the fact that the person has information and has been, is being, or will be helpful in the investigation or prosecution of that crime. So quickly, special immigrant juvenile status is available to certain minors who are involved in the dependency system, and the minor must be under 21 years of age, not married, and inside of the United States at the time of filing. In order to file a petition for special immigrant juvenile status, a state court, which is often the dependency court, must find the following: that the minor is the dependent of the court, that it's not in the child's best interest to return to their home country, and that they cannot be reunited with the parent due to abuse, abandonment, neglect, or a similar state law reason. So it's really important to remember, like we talked about earlier, that the impact that these findings have. So in the case of special immigrant juvenile status, if a child obtains lawful permanent resident status through this option, that child will never be able to obtain immigration benefits for the parent that is identified in these proceedings. So again, move forward on these with care. It is a great option for kids where both parents have abused, abandoned, or neglected them. But when you think about our case hypothetical today, really the mother in that case did not abuse, abandon, or neglect Roberta. So the impact of Roberta seeking special immigrant juvenile status would be huge if she could not then bring her mother back to the United States down the road.
Just real quickly, to touch on asylum, it came up in Maria's case, and I know especially those of you who are DV advocates have probably been hearing a lot in the media in the past couple of weeks about DV asylum and the recent matter of AB decision that was handed down by the Attorney General. We're still evaluating the implications of that case, and so I'm trying to encourage people not to write off domestic violence as a ground for asylum, but rather to take an individual case where you think that there might be domestic violence in the home country to a qualified immigration attorney for consultation. Obviously, eligibility depends on a variety of factors, including the date of arrival in the U.S., whether the domestic violence was on account of an individual's membership in a particular social group, and as a caveat, there are so many administrative changes that are taking place right now that asylum law is sort of a shifting terrain. So what is true today may be slightly different tomorrow. I think looking back on all of the forms of protection that we've just talked about, talking to an immigration attorney is really the way to go. Melissa, do you want to skip the final two polls in the interest of time and just highlight the services? Or
I think so. I think you're all able to pull up the PowerPoint through the materials link. So the next couple of slides, we were just going to go back to our case scenario, but we've actually already kind of done that just in our conversation. And if you look back at the PowerPoint, you'll see we've talked about some specific services that social services could and should provide to the family in the case scenario, and please go back and take a look at those. But again, I think we've talked quite a bit about them. So Emily, why don't you, maybe I'd like for you to touch on this page, and then just know that the last few slides we have are really just full of links, legal resources so that you know who to refer these folks to, so you can find legal services entities, and different online resources for immigrants and victims of domestic violence.
Great, thanks, Melissa. And speaking very specifically to resources when you are trying to locate or work with an individual who's in ICE custody, one of the most important resources to be aware of is ICE's online detainee locator system. The website is on the slide there. If you can't find an adult in immigration detention, try putting them into the online detainee locator system. If they are not there, there are two possible outcomes. They may not be in immigration custody, or they may have already been deported. On questions of ICE's own policies and procedures, again, non-binding, but still very important to be familiar with and to try to hold the agency accountable to, the ICE directive on detention and removal of alien parents and legal guardians, and also the agency's fact sheet on policies and procedures involving detained parents and legal guardians are helpful tools. If you want to communicate with ICE in your local jurisdiction, we've included the website for each of the ICE field offices across the country. If you contact any of those field offices and ask for the child welfare point of contact, you should be able to find someone to speak to. Each office does have one. But if you're finding that you're not getting anywhere with the field office, you are absolutely able to elevate cases and requests to ICE headquarters, either through the email address on the screen or the ICE detention reporting and information line. Although I will note that the drill line in particular, but probably also the email box, are quite overloaded right now with requests about families separated at the border. So if you have an acute case, be patient, be persistent, and feel free to send me an email offsides, and I would be happy to try to help as I go between the headquarters and an individual case.
So those of you that are still on, you'll see we have a list of legal resources. Those can help you find attorneys or other immigration professionals that can help with these cases. Some really great resources for those of you that are working with immigrants that might be facing separation and deportation, online resources for immigrants. And there are some culturally specific resource centers that target victims of domestic violence. So we are one of them. We're the Resource Center on Child Protection, Domestic Violence, Child Protection, and Custody. Here you have the 4 culturally specific resource centers. They can provide training and technical assistance. I would absolutely recommend that you take a look at their websites and reach out to them. And as Emily has said, you're free to contact either of us with any questions that you have about this. If we don't have the answer for you, we can certainly try to find folks that can give you the answer that will help you out. So thank you for sticking with us for a couple extra minutes, and thank you for joining us today.